I am Stacy Lutkus, and as a member of both III and IWIRC and a partner here at McDermott, Will & Emery, it's my pleasure to welcome you to this celebration of the 5th anniversary of the promulgation of the UNCITRAL model law on enterprise group insolvency. McDermott, Will & Emery has long enjoyed successful partnerships with a number of United Nations commissions and programs. And we are honored this evening to host esteemed delegates to UNCITRAL Working Group 5, as well as friends and colleagues from around the globe for what is sure to be an informative presentation. And now I will cede the podium to Evan Zucker, co-chair of the III USA Canada Caribbean Regional Committee and member of the III delegation to UNCITRAL Working Group 5, and a good friend of mine, for an introduction of our distinguished panelists and the subject matter that is the topic of their discussion.
Thank you. So very briefly, I wanted to welcome you on behalf of the International Insolvency Institute, IWIRC, and UNCITRAL to this anniversary conference. Although the model law is not yet adopted, we think it's prime time to talk about the benefits of the model law on enterprise groups and why it should be adopted. And tonight you'll hear from a few distinguished guests. As moderator, we have Debra Grassgreen, who is the immediate past president of the International Insolvency Institute and a partner at Pachulski, Stang, and Ziehl and Jones, excuse me. For the past 10 years, she has participated in UNCITRAL's Working Group 5 and has expert meetings as an NGO delegate. Chief Justice Geoffrey of the Ontario Supreme Court has been an advisor to the Canadian delegation to UNCITRAL since 2008. He has also participated in expert group meetings in connection with UNCITRAL areas of law and insolvency. Irit is a professor of international commercial law at the University of Warwick School of Law. Since 2006, Irit has been acting as an expert advisor to the UK government's delegation to UNCITRAL. And finally, but certainly not least, is John Pottow, who is the John Philip Dawson Collegiate Professor of Law at the University of Michigan Law School. John serves as one of the United States delegates to UNCITRAL. Debra?
All right, can everybody hear me? Do I need to hold this up? Can you hear it from here? Okay, this is high tech Stacey's got here. All right, so this is going to be a discussion that we're going to have, and Stacy is floating around. There are a lot of people here who are involved in the adoption of the law on enterprise groups and that participated in deliberations and might have viewpoints. So raise your hand, Stacy will grab you, jump in. This is not going to be a long discussion. We're going to be chatting for maybe 35 minutes. I've got my phone here only to not for social media, but to watch the clock. And because I know everybody really wants to have informal discussions, but UNCITRAL Secretariat, I want to just recognize Samira, who's here, wanted to acknowledge the occasion of 5 years since the passage of the enterprise groups law and see where we are since the 5 years. So we're going to start with Justice Morawetz. What is the practical problem that the law was trying to solve, the groups law was trying to solve?
Thank you, Debra. And first, thank you, Stacy and Evan, for the kind invitation. A spectacular location. And as we looked out over the Roosevelt monuments in Roosevelt Island, I thought I would borrow something from one of his speeches. January 10th, 2009, and the day that in the insolvency life in Canada will live in infamy. Something called Nortel Networks filed its insolvency that day. It has now just had its 15th birthday. I supervised this file for a number of years from 09 to 13, then gave it away to my former colleague, Frank Newbold, and then he gave it back to me in 2017, and I still can't get rid of it. But it goes down as perhaps the poster child as to what the enterprise group law is intended to try to solve. So some of us actually go back far beyond that project into the original model law. 1997 adopted, 2009 adopted in Canada, restricted in its purest form to single entities. That really doesn't work today because everything that I see in our court, and a lot of it goes right down to New York or Delaware or Texas, involves enterprise groups. So the model law, the original one, certainly was a major benefit, a major step forward. And it has served the test of time and has been, I think, enhanced recoveries right around the world. It is based on a COMI and the international cooperation. It gives you commercial and legal certainty, fair and effective proceedings, enhanced recoveries, but it does have its shortcomings. And now we go to Nortel. Why did it have such a problem? Well, it had about 70 jurisdictions in which it was incorporated, its subsidiaries. They operated in well over 100 countries, worldwide manufacturing facilities, worldwide sales, tax planning in I don't know how many different countries. And then to complete the perfect storm, no secured creditor. So you had innumerable legal issues, innumerable priority disputes, local laws conflicting with each other, and everything went very well in what they called the asset realization. They pulled in about $9–10 billion. Everything did not go so well when they got to the issues of allocation of value and distributions. It took forever and chewed up about $2 billion worth of legal fees and administrative fees. 5+ years later, there was a joint trial because they couldn't figure out where to have it, whether it was going to be the UK, the US, Canada. You also had France involved with major jurisdictional issues there. And the tragedy is that years went by before very vulnerable creditors received any type of distribution. The number of long-term disabled and former employees who died during this process with no recovery was tragic. So how do you resolve these issues? Would they be any different with the enterprise group? Would you have had the possibility of a planning proceeding? Would you have had a group insolvency proceeding? Quite possibly. It certainly would have been different had there been a secured creditor or a group of secured creditors driving the process, but they did not have it in that case. But out of all that, came the realization that a model law and enterprise groups would potentially solve some of the problems and enhance recoveries, further the international cooperation. And I'm now going to turn it over to John, who I think is going to give you a little bit more detail about the enterprise group law.
Okay, well, thank you very much. And since this is so here we are.
That's an inside UNCITRAL joke.
This is inside UNCITRAL. But I do want to thank our host of the Triple I and IWIRC and McDermott. Is very generous for you to put this occasion together and to talk about the 5th anniversary of it. Yes, we bear culpability at UNCITRAL for putting this together, but we are optimistic that it will actually help and bring some order. So for those who are less familiar with the groups law, I was actually going to do the nuts and bolts a little bit of how it works and try not to anesthetize you at this hour. As Jeff said, the motivation of it was recognizing that what worked, or what I would say worked well for the model law and cross-border insolvency, is this centralizing idea of COMI, the idea that you pick the center of main interest for a debtor and use that as a centralizing vector for how to coordinate a cross-border insolvency. And it's premised on a single entity. And so when, and the legislative guide, part 3 of the legislative guide gets into this a little bit, when you have a conglomerate of multiple organizations, COMI doesn't have a natural answer to that. Well, there are 2 poles. One, you could say, is find the COMI of every one of the 78 subsidiaries and run them all through the model law cross-border insolvency. Or you could try to find what's been called, the e-COMI, the enterprise COMI of the whole shebang of all the affiliates together. And there's pros and cons with either one of those approaches. I think some on the academic side might be normatively attracted to the idea of an enterprise COMI, and some people who are terrified, rightly, of academics say that's the stupidest idea I've ever heard, because it will basically require substantive consolidation of all the affiliate assets, to which some of us might say, great, and some might say, my God, no, capital will stop and we'll all die. I got a good lecture today about how capital markets work. And the necessity for protection of secured credit. UNCITRAL did what UNCITRAL does well, which is try to move the ball forward with a sort of incremental consensus-driven approach. And that's what the group's law is. And so it, looking at it through the lens of Comey, it conspicuously and deliberately does not take an e-Comey approach. It does not say, let's try to find the e-Comey of this whole group. What it does try to do is facilitate some coordination and cooperation of a messy international proceeding. And it does this through this tripartite concept, which is either circularly or quasi-circularly, which is ovular, I don't want to say quasi-circular, as a definition of the idea of a planning proceeding, a group insolvency solution, and the representative, what's it called? The group representative, thank you, okay.
I think that's a triangle.
It is a triangle, quite close, well done. It's a triangle. The reason why I say it's semicircular is because the definition of the group representative is someone who's trying to come up with a group insolvency solution. And a group insolvency solution is what's resolved at a planning proceeding. And a planning proceeding is what hosts the creation of a group insolvency solution. Now, it's a little bit glib. There is a definition. The idea of a group insolvency solution is to come up with what we would call a plan. But it's modest and it's modular. So it doesn't have to be every single entity in the group has to be in it. It can be one or more parts of the groups. It doesn't have to be all the jurisdictions. But the idea that it's bigger than just the siloed approach of each individual thing. And the thinking is that if you can have a coordinated, centralized group insolvency solution, then that will have some sort of respect-inducing, agenda-setting, cooperation facilitating impulse for the various ancillary proceedings around the world. So it's one thing to sort of build it from the ground up, which is what you had to do before it was. So you look at, I wrote an article about the Hertz insolvency proceeding where you had stuff going on in the UK. There was a scheme, then there was a chapter 11, then for good measure, they put in chapter 15 to implement the scheme. And so you had a 15 and 11 together as a, what's that, a 26, 36, okay. And because there was, and it was just, the main purpose of the British scheme was to get some debt readjusted in Delaware. I think it was US debt that they were doing through the British scheme. And so the whole premise of the scheme was to come and ask for permission. And they said to their scheme papers, like, here's what our plan is. Our plan is we're going to ask a US court to do something. And the British judge is like, great. So if we had had a group insolvency solution, right, like taking place in Delaware or in London, whatever, and we say, here's what we're going to do, and this is actually being proposed by the group insolvency representative who's designed to come up with a group solution, that has a very different valence, I think, for a receiving court as opposed to something that just comes sprung up from the party's own thing, because it's something that's been deliberately planned.
I'll stop you there for a sec and just ask a question for the benefit of the group, which is, can you explain to everybody who gets to decide which is the planning proceeding, where is the planning proceeding, you know, is that subject to manipulation? You can answer.
No, this is a very good question. It is party initiated, but the main thing is that Comey has not gone away. Okay, so I don't want you to think anyone's getting away from Comey with this group insolvency law. Comey is here and she's proudly rearing her head. And I think this is important because we have, as we've learned today, and UNCITRAL is very sensitive to this, we have different insolvency traditions and cultures around the world, and you're not going to get a unanimous agreement necessarily. And so the idea of having a big enterprise-wide Comey for everything would just be infeasible. And the idea of having individual Comeys for silos would not work either. So there's party initiation, but a planning proceeding must be housed at one of the affiliates that is a, quote, necessary and integral part, if I'm getting the quote right, of the enterprise, of the international enterprise. So what you can't do, and this is going to disappoint the New York bar, is you can't go open up a bank account and say, we found where the planning proceeding is going to be. And I know that those of a certain bent will be, but that will reduce the efficiency of racing to the best jurisdiction with the most virtuous laws. But we haven't gone and said, you've got to find the Comey and do it only in one jurisdiction. So that's, I think, a very important policy compromise that says you don't have to do it at the main Comey. You can't just pick any place. It's got to be something that's plausible. It's got to be an important affiliate. And as long as it's within the constraints of being a necessary and integral part of the enterprise, the parties can initiate where the planning proceeding is going to be.
Then you open the planning proceedings there, and then other entities may participate in that planning proceeding, and then the group representative will develop a group solution. And then in those places where the other entities have their commies or establishment, those receiving courts may actually decide not to open additional proceedings in the local forums, but rather defer to the planning process. This is especially if you implemented also the supplement
Yes.
in the model.
That's the goal, right? The goal is to avoid having multiple proceedings in multiple jurisdictions because of the cost, because of the risk of inconsistent decisions.
Exactly. So
Pressure.
it's two goals, exactly. It's reducing costs. Nortel took forever. So instead, we started with the planning proceeding, for example, in Canada, and we avoided applications. At the same time, we also facilitate coming up with a group solution that can also maximize value. So it's reducing costs, maximizing value, and allowing reorganization for the benefit of the relevant stakeholders of the relevant participating entities.
So Irit brought an important point up, which is that I've been focusing on what I call the upstream impact of the group's law, which is the planning proceeding, and the idea that you're going to have one court coming up with what should be an enterprise-wide solution, or at least a substantial portion of the enterprises. It is completely modular. You can leave some of the entities out of the planning solution, that you don't have to do it. And participation is voluntary, which is very important for entities who are sensitive about subjecting themselves to the jurisdiction. You can participate in a planning proceeding without formally becoming subject to the jurisdiction of that court. You're just showing up and you're sharing your thoughts about what should be done. Okay, it's like a limited appearance, we might call it in some systems. But there's also downstream effects, which is if you get a planning proceeding and a group insolvency solution successful, that court can enter a plan or enter an order, do whatever it wants. But of course, sovereignty, international law can't compel the various jurisdictions around the world to enter its order, right? That even though it's elegantly styled the group insolvency solution. And so as Irit has adverted, there's a second chapter, I don't know, of the model law. That's really important. Do you want to explain that one, Irit, if I put you on the spot?
So generally, and that's in the main part, the receiving courts. So there's the relief parts, and the relief can be given in the planning forum in order to advance the group solution, and it's quite flexible. And then there's the relief that you will seek as a group representative in the receiving courts. And that can be all sorts of relief, but it can also include, and that is in the supplement, it can also include seeking to avoid the opening of additional proceedings, even if there are additional commies in other of relevant entities in foreign jurisdictions.
So we're going to talk a bit about, it's been 5 years, but the legislation turn slowly, and so it hasn't been adopted anywhere. We're going to talk about that, and we're going to talk about the movement towards it. But Jim, how are we dealing with it right now since it hasn't been adopted?
In very strict legal terms, you fake it till you make it. The first time I had the problem was an entity, I think our UK group might identify with Massachusetts Elephant and Castle. British-style pubs that were operating in the United States and Canada. You had 15 entities. 8 were in the United States, 7 were in Canada. It filed in the US, and this was under the existing model law, and then comes for recognition in Canada. You have uncertainty and chaos of outcome, because technically you have to do a comey analysis for each one. And where does that lead you? Well, in this particular situation, if it led to a conclusion that the comey of the 7 entities in Canada was in Canada, then you embark on concurrent hearings, joint hearings, delay, expense, and guess what? 15 pubs are now out of business. Nobody's happy. So yeah, you bent the rules and you come to a conclusion that the center of main interest, and you try to find some factors to hang your hat on, were in the United States so that you could get to a practical result and save the entity. But therein lies the problem. At some point in the future, it's not going to go very well. And then you have, as I said, chaos, uncertainty, and all the objectives of the model law go out the window. So that's where you are right now. Fortunately, I think there's enough jurisprudence that, the judges certainly in Canada have got the message. Come to the right conclusion, save the entity, save the jobs. And obviously, you're going to be listening to the wishes of creditors. And if there are dominant secured creditors, that's usually going to carry the day.
Well, so it does look like the UK may be close, but close. We'll see there's a few folks here who might have a view on that characterization to adopting the group's law or a version of it. So, Irit, can you tell us what's going on?
Yes, so yes, the UK has started the consultation in 2022, concluded that consultation efficiently in 2023 on the adoption of the model on groups. And that conclusion is a super positive one because it says that the UK has decided to adopt the model on groups as soon as practicable. And yes, we have Mark Smith and Natalia and Simon here from the Department of Trade, the legal advisors and the Insolvency Service, and they may be able to say a word about what is the situation at the moment. I will just say sort of a few words on what we can see in the public documents, in the consultation outcome, and what we can see there is a decision to adopt the model law on groups, not a version of it, but actually the model on groups. Of course, you need to kind of adjust it to your local circumstances, but at least from what we can see in the public consultation, the idea is to adopt the model law on groups more or less as it is, including that supplement. And the reason why it is called a supplement in the model law itself was because there was a lot of discussion and some level of controversy in the working group at the time. There was a concern that perhaps avoiding opening additional proceedings where the COMI is located is perhaps a step too far, as John also mentioned. We managed to reach a consensus, but we called it a supplement to sort of flag the fact that this is perhaps more ambitious. So it is important that we can see in the consultation outcome that the decision is to adopt the entire model on groups, including the supplement. What we can also see in the consultation is sort of an explanation of what the participants in the consultation mentioned and the government response, saying that they think that adopting the model on groups will significantly could enhance the cross-border insolvency framework, that it can benefit stakeholders, especially in those cases where the group is rather large and more decentralized, so it is difficult to find a mutual compromise, so circumstances like those in Nortel. It is also acknowledged that the actual impact and the benefit of the model on groups, this is also mentioned in the consultation, will be felt only when more countries adopt the model on groups, and then it becomes more inclusive, and that is sort of what is behind it, so that we can do this participation, this planning proceeding that includes the relevant entities. Again, if we're back to Nortel, eventually you did manage to reach some kind of cooperation with the US court, but it was much more difficult to include the other entities in the EMEA region, and especially those located in countries that didn't even adopt the model on cross-border insolvency of 97. So it is acknowledged again in the consultation, back to the UK consultation, it is acknowledged in the report, in the outcome, that we need more countries to adopt the model on groups in order to feel its impact and its benefit. But it is then also acknowledged that someone has to start the process, and the UK sort of saying, again, at least in the report, and we may be able to hear from our representatives, but they are saying the UK could be one of the leaders or leading jurisdictions that start that adoption process, and hopefully that can inspire other nations.
Hear a bit about it, and I think we might have some that aren't familiar with what a consultation process is and getting federal legislation. So, someone want to explain that? I think we've got a mic.
I don't mind.
Simon or Mark? Okay.
Right. Well, I'm Mark Smith. I'm the lead lawyer of the team drafting this law. We are drafting it. There are things I can tell you officially, which is we're drafting it. I can now tell you something unofficially and off the record. We have drafted it. We've found a way of doing it. It's not straightforward. However clever we are in the working groups, we do leave quite a lot out. We have 3 jurisdictions to deal with in the UK. So we're now working on the procedural rules for each of the jurisdictions. If it then gets political and policy approval, that's a final stage, and parliamentary approval, and we go through various policy clearances. That's right, Simon, isn't it? So there's still lots of ifs in there. it may well become law. But if anyone wants to talk to me about how we've cracked it, I'm very happy to on an unofficial, unattributable basis.
Thank you.
I'm Simon Whiting from the Insolvency Service. Oh, push one button.
Green.
Green is on.
Green is on.
Oh, thank you. Yeah, Simon Whiting from the Insolvency Service, which is the UK government department which is responsible for insolvency. One thing I wanted to add to what Mark said was that we're very pleased to say that we've actually made very, very minimal changes in the draft to the actual model law itself. And we were very keen to keep to the text of the model law. Of course, the closer we keep to the text, the more useful it is for everybody. And we, having looked at the draft, we were able to keep very closely to the text with only very minor modifications to accommodate British law. So that was all I wanted to add.
Thank you. We're rooting for it, right? Because somebody's got to be first. Someone's got to take the first step. So we're rooting for it. So so Justice Morawetz, you did tell me I could call you Jeff, but struggle with that. But what's happening in Canada? Are there some efforts in Canada?
Yes, there certainly are. And these things do take time. And it took the model law from 97 to 2009 to surface in Canada. I think a lot of it is, it's a profession, whether it's the accounting side or the regulators or the legal, they do not embrace change. And they tend to probably look at it through their own lens, which is, how is this going to impact the profession? How is it going to impact my own business? And it took a long time to educate that group before the adoption of the model law. And I think we've got the same problem now. We have not done a very good job of marketing the model law and cross-border enterprise group, and that has to change. In Canada, the federal government is now engaged actively in a stakeholder survey, trying to, I guess, get the impact and the comments from the profession. After that point, if everything goes positive, you then have to have a bill drafted. We have to actually go right through and enact a bill through our parliament. You then have to convince the political people, because generally insolvency does not attract an awful lot of attention, or positive attention, shall we say. And they have to introduce a bill and get it through Parliament and then have it enacted. So I'm confident that it will come. It's just a question of when, but it's a little bit more complicated than the process that the UK has to follow.
Do you think it'll be easier if the UK passes it to get it passed in Canada?
Absolutely. It'd be even easier if the United States went forward too. But, I think you're going to find.
I wouldn't hold your breath on that one.
Yeah, I know, but these things do, as I said, they have to take time, Debra, but once you get a momentum, and you can see it now with the model law, the existing model law, and how well it's spread in the last 5 to 10 years. So it'll come, and hopefully during my lifetime.
The US experience will be somewhat different, I predict, in as much as nothing has happened. Here's how we do bankruptcy laws here. We establish commissions that are supposed to do like a ground up analysis of how this is how we did the 1978 bankruptcy code. Last time we put one of these commissions together, a blue ribbon commission, it was in 1995. They spent a couple of years putting together a big report, and Congress ignored it and did nothing. And then what happened is the banks came and dazzled a lot of money before a couple congressmen, and we passed a law that was called the Bankruptcy Abuse Prevention Act, that reformed the bankruptcy laws to be more punitive towards consumer debtors. Now, because that's something creditors can lobby interest behind, right? Chapter 15 was lucky to get in because they just quietly tucked it in the consumer law. Chapter 15, our biggest international innovation in commercial law in the United States, was passed on a law called the Bankruptcy Abuse and Consumer Protection Act. That's how we got it into law here, okay? So then now we're in the next phase, and so don't worry, public-spirited nonprofits have taken up the slack. And so we have the American Bankruptcy Institute, which convened the Commission on Chapter 11, put together an even longer report on great reforms to our Chapter 11 system. And not to be outdone, they also put together a consumer bankruptcy report of how to reform our consumer process, and had hearings around the country. And so they got lovely reports. I got them in my office. And nothing will happen out of them either. In fact, maybe they'll make someone irritated. So how will we get these bills passed? I don't think anything will happen unless some visible and important trade group says this is something we need from industry. Nothing on academic rights is going to make a difference I will defer to my superiors at the government. If anything the government says is going to make a difference, absent some industry support. Or maybe, does anyone from the U.S. government want to be put on the spot to opine on the thing? I'll look around the room. I don't think so. No? Okay. So that's about all we have to say on that.
Karin, no? I can see Karin.
I'm not sure I need a mic.
Good projection.
We're coming with the mic.
Yeah, but just to say that this is one of the things that we have sort of struggled with is the chicken and the egg. We need to have interest from the industry. We need to hear that type of support before we can begin to even start the legislative process. And I will not opine on the state of the legislative process in the United States right now, but to suffice it to say that it can be difficult to move legislation through both houses of Congress at the moment. Thank you.
Okay, so a question for the panel and actually for the room. Does anyone know of any other jurisdictions that are moving towards adoption?
I'm aware of, I won't name the jurisdictions, but I'm aware of jurisdictions considering as a package. So jurisdictions that are thinking about adoption of the model on cross-border insolvency 97, and in that context of that discussions, they are also looking at the new model laws on judgments and on enterprise groups.
All together.
Sometimes two of them, sometimes three of them.
That may be one of the best shots, is to do it all together in places that haven't even adopted the model law on cross-border insolvency. What are the challenges in persuading
I mean, generally,
countries to adopt?
persuading, adopting any international instrument that is supposed to promote cooperation and adopting it domestically is challenging, because there's always the concern that John mentioned about surrendering some sovereignty, which is sometimes quite irrational because we are focusing too much about what we are surrendering and much less about what we are gaining from cooperation. But that is the reality. And regarding groups, in addition to that, you have the concern about the corporate form, which John also mentioned at the beginning, right? Is it going to be substantive consolidation? What are we? So that exacerbates the fear and can be challenging. The model on groups does take that into account, as John explained. So it respects sovereignty, it respects the corporate form, but we need to highlight these issues and the benefits of the model on groups when we try to persuade countries. There's also the issue of the complexity, which is inherent to a model law, to any law related to enterprise groups, because groups are complex thingies, structures, right? And so especially countries that didn't have a lot of experience with cross-border insolvency cases, they didn't adopt the model law on cross-border insolvency of the 97 model law, or adopted it but didn't have a lot of experience, they may be worried about adopting the group's model law. And so we need to also pay attention to training and capacity building when we think about persuading countries to adopt, so that it's also meaningful, it can be actually used.
We talked, I think, a little bit about the technical aspects, about getting industry groups and getting out there and educating. And there are projects. I know III, by the way, just a little bit of a plug, has a project to encourage countries to adopt the model law across years. And so it's interesting to me to hear that, you know, from various jurisdictions, that getting groups and people like the people in this room to be active will perhaps help. But what are the other technical aspects? Anything else we can do?
Well, again, promoting. You know, we've not, as I said earlier, we've not done a very good job on marketing. Then the next thing is, you know, it does, unfortunately, you have to get into the political arena. And a bill like this, or a model law like enterprise groups, should not attract an awful lot of controversy from the legislators. You know, if you've made the business case for it, it's a win-win for all sides. But is that the way in which politics are operating these days?
I actually think that there is a role for, so like organizations like the III and the American Bankruptcy Institute, the American College of Bankruptcy, rather than trying to come up with rival reform projects and say, we've done our study and this is how you should do it, what they should do is write letters and say, we are a nonprofit that focuses on bankruptcy law. There's been this thing put out by the United Nations that's a model piece of legislation. We think you should enact it. And that, I think, would be a more efficacious intervention and salience point for those nonprofits than all the hearings they had on reforming the bankruptcy code.
Does there also need to be, a lot of times this legislation comes out of, problem, right? That's where we started. What was a problem that we're trying to solve? Does there also, unfortunately, Nortel was long and expensive, but it got, right? It got done. And these other cases are getting done. So does there need to be a bad example for folks to then say, look, this is what happens if we don't do it? Unfortunately, do we need a stick rather than a carrot?
I think we can mention the bad examples of the recent crypto cross-border cross-border insolvencies, where at least initially it was really difficult to cooperate. And that is also linked to our other projects at UNCITRAL, asset tracing and recovery. So it was also difficult to locate the assets and bring them to the right places. It was a group, FTX, etc., entities not cooperating. There is no framework to just centralize it, have a planning proceeding, coordinate. So we can mention the more recent cases as well, and we can also mention the link between the model on groups and the other model laws and the other instruments, including the forthcoming ones on asset tracing and recovery, for example.
I think that's a good point. That needs to be part of the marketing, not just positive marketing, but unfortunately a little bit of negative marketing. What happens if it doesn't go right? So I promised you all would be drinking by 7:30. We have 4 minutes. Are there any questions? I stick to my timetable. We got any questions? This is not a shy group, I know. No one? Oh, okay. Judge Peck. Jim, I can call you Jim, right?
Do we really need this? That's really my question. But my question is this: do we really need this? Is this something that the world needs to be a better place for insolvency? And if it isn't picked up, don't we have the tools now to manage group insolvency cases? In Lehman Brothers, even though there was no law that related to it, New York was deemed the center of main interest. There was a protocol on cross-border cooperation. A plan was put together in 3.5 years. And the creditors received well in excess of anything anybody could have imagined. It was a very successful case. And in fact, years ago, we had panels in which we compared Lehman and Nortel. Nortel was the stepchild, and Lehman was viewed as a great success story. So it's possible to have success in global insolvency involving groups just like Lehman or just like Nortel without this law. So what I would like the panel to do is not talk about the marketing that's needed, but tell us, all of us, how we can market it because it's needed. Because if there isn't a perceived need, it's never going to happen.
Of course, but even in Lehman Brothers, Jim, it took a while. That protocol that you're talking about wasn't accepted by everyone, including the UK administrators. There were many entities opening proceedings in other places, so it wasn't generally accepted that the COMI of all the relevant entities are in New York. And eventually it was a success, but it took time. So imagine a world where there is this framework and you could do it much quicker. You can open a planning proceedings in the United States, entities in countries that also adopt the model on groups, understand that model, understand that framework, more quickly cooperating, opening all the proceedings there. Perhaps we could save time. Of course, we can see Lehman Brothers as a success story at the end of the road, but its initiation also initiated lots of other problems in our global economy. If we could have dealt with it quicker with a better framework. So yes, we can voluntarily and an ad hoc case-by-case basis and with good judges create some solutions, but we can imagine a world where we can do it more efficiently.
What Jim was trying to say is that he got it right and that Kevin Gross and I got it wrong, right?
Is it possible for the panel to give us bullet points? Because we could be emissaries for this law.
Sure, let me
What are the bullet points as to why it is that this law will make the world a better place for cross-border insolvency?
So I would ask that the same way that we didn't need Chapter 15, and yet Chapter 15 was a tremendous success. We did Maxwell without Chapter 15, but it was more cumbersome and more expensive, okay? And then we did Chapter 15. Same thing, we can muddle through without this, but it will make it cheaper and we'll have greater reorganizations, more likely to be reorganization than liquidations. What it specifically does is actually in these supplemental relief provisions is it gives legal jurisdictions that don't have the history of discretion that common law jurisdictions have, affirmative authority to close down and not open unnecessary proceedings. And that's a great empowerment to some jurisdictions. Because right now what you have to do if you want to implement a solution is you have to go and open up a solution and say, hey, let's have a vote under our local laws and put all the ballots out there. And then now we can implement this in this ancillary jurisdiction. By giving the planning proceeding the power to predetermine that this is going to be the group solution, and then also empowering the local courts under the relief provisions to say, if you're satisfied that you got adequate protection, you can close or decline to open an insolvency proceeding. That will speed things up and make things much cheaper and easier.
Predictability, certainty, efficiency, enhanced recoveries, decreased administration costs. That may not fly well with the profession. I understand that. You know, that's the objective. And again, I'll follow along from John, you know, do we really want to go back to, you know, the pre-model law days when you had concurrent proceedings in, you know, 2 or 3 or 4 different countries and just flailing around until you eventually get to a solution? But, you know, I think that a lot of it is going to fall to the, you know, the secured creditor groups to drive this thing through because they're the ones who are going to benefit from it.
Right. That's great. I think we're only a minute or two over, so I'm going to hand it over to Kat.
Hi, thank you very much. I'm Katarina Crimson. I'm part of the IWIRC delegation, and I'm very aware that I'm between you and a drink. So let's keep this short. Can I invite you all, please, first to thank our panel for their thoughts. And then I'd like to thank McDermott for hosting in this terrific venue.